Thank you. Please be seated. Before I call the first case, I just want to welcome some new employees of the court system, our hardworking clerk's office and the clerk's office in Thurston County District Court, who are here observing court as part of their orientation with our Human Resource Director, Jane Van Camp. Could I have you stand so we could acknowledge you? Oh, they're hiding over there. Well, welcome. Welcome. Oh, really acknowledged. We appreciate all your service to the courts. The first case this morning is in re the personal restraint of Saeed Omar Ali. I have Mr. Parker presenting for 7 minutes, then Mr. Ellis, amicus for 10 minutes, a response by Ms. Meckling for 20 minutes, and then Mr. Ellis has 3 minutes for rebuttal. Counsel.
Good morning, Your Honors. May it please the court, my name is Corey Parker and I represent the petitioner, Saeed Ali. After almost 8 years after Saeed Ali's judgment and sentence became final, this court decided Houston Sconyers. In Houston Sconyers, this court noted that the 8th Amendment to the United States Constitution requires courts to recognize that children are different. This court reasoned for the first time that because children are different, the 8th Amendment mandates that trial courts have absolute discretion to impose sentences below the SRA standard sentencing ranges and mandatory sentence enhancements when sentencing a juvenile in adult court. Now today, the court is faced with a case where the sentencing court's own words that she had no legal justification, that her hands were tied, reflect that the court's sentencing error actually and substantially prejudiced the child defendant. As a result, this court respectfully must decide whether Houston Sconyers' decision is a significant material and retroactive change in the law. Now, I'd like to focus my argument on how Mr. Ali was actually and substantially prejudiced, while my amicus counsel, Mr. Ellis, will focus on the retroactivity analysis. Your Honors, the sentencing court's words at sentencing and the fact that he was sentenced to the low end of the range demonstrate by a preponderance of the evidence that Mr. Ali's sentence would have been shorter if the trial court had absolute discretion to depart from the SRA at the time of sentencing. Now, if we look at the actual words of the court stated, quote, "There is no legal justification that would allow a sentence outside the standard range." The court said, "I'm required by law to run the 3 24-month deadly weapon enhancements consecutively to each other."
Is that what you think it takes to prove prejudice? Does the judge actually have to say that, or is it enough that youth was not meaningfully considered by the court and that the parties didn't even know that they had the option to assert the judge's authority to depart?
Your Honor, I think it's enough. I think the Ramos case tells us that silence doesn't constitute reasoning. And I think that in cases where the court is silent or doesn't consider youth, that's enough to substantially and actually prejudice the defendant in that case.
And to know that, do we have to have the transcript of the sentencing hearing? And who has the burden of producing the evidence of what did or did not happen at that time?
Your Honor, I think that the burden is on the petitioner as far as post-conviction purposes. I think that what we'd like to do moving forward is give a directive to the trial courts as to how to proceed in situations like this involving children. But I think if the court errs and doesn't reason properly, then the burden would be on the petitioner to provide the appellate court the reasoning for substantial and actual prejudice, either on direct appeal or through a personal restraint petition. But ultimately, I think that the burden should be on the court, that the court should recognize presumptively that they have the directive, as stated in Houston Sconyers, that they have to consider youth, that they have to consider departing from the SRA, and that there is no set SRA that they have to go through when it comes to juvenile defense.
So can I ask just for clarification, because this is a personal restraint petition where the showing of actual and substantial prejudice must be made by the petitioner. Does your answer indicate that that showing is made unless the record, the transcript, would show that the court actually did consider youth and found it unavailing, that silence would make that showing, as would a record of the sort you're indicating here?
I do, Your Honor. I do believe that silence would, again, as the Ramos case says, that silence doesn't constitute reasoning. And so if we look at, if we look at this case at hand, it's very obvious the evidence that was considered by the court and the evidence that was elicited, that my client was a refugee after a bloody civil war in Somalia. His father was killed before he and his family fled. He endured extreme turmoil in his life. He briefly lived in a Kenyan refugee camp. He lost his father. But if we look at the Mepin case, there wasn't a showing of the showing was that there was a cold, calculated, and indifference towards another human being. That's what the court concluded. But I agree with the dissenting opinion in that case that there was, because it wasn't considered, because the court didn't actually have any findings related to youth, and there wasn't any evidence that it was considered.
But we've been clear in Ramos, as has the Supreme Court in Miller, that findings aren't required.
Findings, while findings aren't necessarily required, we believe that there should be written findings, as there are with the Kent factors. There should be some sort of standard that does require written findings. My question goes to really then, there will never be a reference hearing then in these sort of cases. Either the record will show that the trial court said something like, my hands are tied, I would give you a downward departure, but I can't, right.
Or and they get relief there, or the record shows nothing, and they get relief there, but only if the record shows, I realize your youthfulness, but I'm nonetheless sentencing you. So there's no room for a reference hearing in any of these sort of cases?
I think that a reference hearing is one way to deal with it, and I think that this court is faced with that decision of how to deal with cases that the court potentially determines that the youth wasn't considered. We would state that if youth isn't considered, that Houston Sconyers tells us that a remand is what's necessary, that if there is silence and if there is a lack of reasoning as to the person's youth and the neurological differences involved as flows from Miller, as flows from Houston Sconyers, that a resentencing is the proper remedy, that it should go back to the court for resentencing to consider the factors that weren't considered in the first place. A reference hearing is certainly an option, but we don't necessarily, I think that logistically it wouldn't be too much of a burden to send it back for a resentencing hearing. I think that we're not, with the universe of juvenile defendants that we'd be dealing with, they're the defendants that are already still in custody. And if this were to apply retroactively, to send them back for resentencing would not be too much to ask.
Would you say that there's a resentencing involved for almost everyone that was a juvenile? Because normally you don't have the kind of evidence or the kind of remarks that this particular judge made.
Right.
Because everyone assumes you have to, sentence the mandatory minimum. So I'm not sure, a lot of defense attorneys would have even brought it up. As in Mippen, he did offer up the mandatory minimum, and that's what his client got. But what do you think about that? Are we going to have mass resentencing? That's my question.
Right. And Your Honor, if I may answer your question, I know my time is up here. I do believe that there does need to be a resentencing. I think that's the only way to deal with this, that if the record is silent, if it shows that it wasn't meaningfully considered, that's the only equitable result here, that we can't, that these juveniles that are children that are getting these lengthy consecutive sentences, that are getting sentences where I don't think that the court necessarily has to say that their hands were tied. I don't think that the court necessarily has to overtly state it in the way that it was stated in Mr. Ali's case. I think that's a telltale sign, and I think Mr. Ali should be given relief for that reason, but I don't think that it has to be to that extent. I think that we have to look out for these children, and that to do otherwise would be cruel. And so just any sort of statement that, or just the judge not considering it as they should be enough.
Thank you.
Thank you.
Thank you, counsel. Mr. Ellis.